your arguments today. We now move to the second case on our docket, Smiley versus the State of Florida.
Is that okay?
That's good.
All right, thank you. May it please the court, my name is Andrea Norgard, and I represent Mr. Smiley in the appeal before this court. This is a direct appeal from a capital conviction. Mr. Smiley was convicted of first-degree felony murder and then 3 other prior or contemporaneous felonies. And in addition to that, there was a second homicide that he was also convicted of that the state did not seek the death penalty in, but did use an aggravation in this case. The initial brief is essentially raised 4 issues related to the guilt phase and then 5 issues related to the penalty phase. This case took a very unusual posture in the trial court in that the guilt phase and penalty phase were bifurcated. And then during the course of that bifurcation, Hurst issued and caused a host of additional litigation before the penalty phase actually began. My intent this morning would be to focus on the issues that related to the penalty phase. I am not, in doing so, not trying to in any way leave the impression that the guilt phase issues do not deserve serious consideration by this court. However, they do not present some of the very factually complicated and quite unusual problems that the penalty phase does present. So with the court's permission then, I would like to begin by addressing penalty phase issues. Okay. The first issue and the issue that I would like to begin with was issue 6 in this case, and that addresses what evidence the state and should have been able to present during the penalty phase given the jury's verdict in guilt phase. And I would like to open by that argument by reading to this court a paragraph from this court's decision in LeBron versus State, located at 894 Southern 2nd, 849. Prior to commencing the analysis in LeBron, we pause to acknowledge the unique factual posture of the case before us, which generates unusual problems. The guilt phase jury determined LeBron was guilty of felony murder, that he possessed a gun, but that he did not possess the gun at the time of the murder, and the victim was shot by someone other than LeBron. With direct evidence, such as presented here, seldom does this court review capital cases in which the guilt phase produces such specific and seemingly inconsistent verdicts. That said, neither this court nor the trial court can alter the original jury's findings with regard to guilt issues. To the contrary, the judiciary's constitutionally mandated role in this context is to ensure that LeBron's sentence is not erroneously premised on facts and findings that would contravene the original jury's guilt determination.
But counsel, what about the verdict was inconsistent here, like LeBron? I understand the argument that there were blanks with regard to the 775087 enhancement requirements that were made on the verdict form, but there was no indication, as I understand on the verdict form, that he did not possess the firearm.
Your Honor, I would respectfully disagree with that assessment. I would also point out that in LeBron, the court did not find there either that the jury verdicts were actually inconsistent, and that was never argued or presented to the court in LeBron. It was that they were seemingly, that was the court's characterization.
I'm looking at the verdict form.
Yes, sir.
Count 2.
Yes, sir.
And there's a check mark by A, which says the defendant is guilty of robbery with a firearm as charged in the indictment. There it is. I don't understand how the failure to check something else is inconsistent. It may not have duplicated what is said there, but guilty of robbery with a firearm is guilty of robbery with a firearm.
Well, Your Honor, I believe that where the inconsistent verdict argument came in this case in the trial court was not between what was stated under each count, but that rather the counts 2, 4, and 5 were inconsistent with the verdict in count 1. At least that was the argument promulgated by the trial attorneys.
And just to be clear, count 1 was the felony murder count?
Correct.
And in count 1, the jury was instructed that in order to find the defendant guilty, they had to find that he is the one that actually killed the victim, correct?
They were instructed...
That was the instruction, correct?
Yes, they were given
Okay.
the interlocking verdict counts. They were first directed to reach a determination on counts 2 and 5. Then if they found Mr. Smiley guilty of either count 2 or 5, then they were to return, because that would have established an underlying felony that would have supported a felony murder conviction, because premeditated murder was never submitted to the jury in this case.
But the jury found, as Justice Lawson was just asking, that Mr. Smiley was the one who actually killed the victim in this case, correct? It had to have.
Well, there was...
Let me ask you this. Was the jury only instructed that they could find the defendant guilty if that fact happened?
I believe that you have to look at the
Can you
verdict
answer
forms.
I'm going to get to your argument,
Right.
but can you answer my question and Justice Lawson's question?
That was part of the instructions that the jury was
Wasn't that
given.
one of the facts that had to have been found by the jury for it to have reached the verdict that it did?
I believe that's one interpretation of these very confusing verdict forms and instructions. So yes, I would say yes, that
Okay.
was part of the instruction.
And then as to each of the other counts, Justice Kennedy read, I believe, count 2, but each one of them actually said aggravated assault with a firearm and burglary or robbery with a firearm, correct?
That is correct.
Right. So the jury found in count 1, because it was instructed that it can only find if he actually killed, and then counts 2, 4, and 5 all indicated that they were done with a firearm, correct?
That was indicated in the first portion of the verdict form.
Right. So I guess I'm having trouble understanding how this is like LeBron, where there's any inconsistency there, even if it wasn't a model of clarity.
Well, in LeBron, it was essentially the same thing. When the jury was asked to make the specific findings regarding the firearms, it was very similar to this case in that...
Except that there the jury actually did find that there was no firearm, at least as to some counts, correct?
Correct.
Here there was no indication of no firearm, right?
Well, my argument to this court is that there was, but that the jury did not make it.
How can you say there was when there's 2 boxes?
Mm-hmm.
One box is he possessed a firearm, one box is he did not possess a firearm. The jury is told to answer that, and they don't answer anything.
Because of the second part of what the jury was instructed, if none apply, leave blank. And I don't think that in an analysis of this nature that it is appropriate to disregard part of the jury verdict form and part of what they were instructed to do.
Let me ask you this. So each one of those, in addition to saying with a firearm, the substantive counts, each one of them says as charged in the indictment, correct?
That is correct.
The indictment here charged that he possessed a firearm, did it not?
The indictment charged that, but we have no way of knowing whether the jury referred back to the indictment, whether that was what they relied upon, or whether they were making...
But they made a finding. They made repeated findings that he was guilty of these various offenses: robbery with a firearm, aggravated assault with a firearm, battery while armed with a firearm, all as charged in the indictment. Those are the primary findings in those counts. Isn't that correct?
I would say that that is the wording of the first statement as to each verdict. And so, yes, could that be in one sense construed as a finding? Yes. However, that finding was qualified in the jury verdict form by what the jury was then subsequently asked to do.
But isn't, counsel, I'm sorry for interrupting you, isn't really the only issue, though, that you possibly have here on count 5? Because in counts 2 and 4, the jury was told that those had to do with Mark Wilkerson, and the evidence was clear that there was no discharge of the firearm with regard to him. And so it made sense for the jury not to check those boxes, given their understanding that that was a reference to Wilkerson. Count 5 seems like that's the only one where there's this possible ambiguity about their finding.
I would argue that counts 2 and 4, because the jury, again, was asked to do this and failed to do this under one possible scenario. 2, they followed the instruction exactly and determined that if none apply, leave blank, that in any of those instances, we don't have a finding from a jury who was specifically asked to make a finding.
But you're not disputing that's 2 and 4
I'm
based
not
on the whole,
disputing-
that they referred to that the jury was told that that was about Wilkerson.
I do not dispute that, no.
Okay,
That is what
and the questions
court
are
clarified.
discharging a firearm, and as a result of such discharge, great bodily harm or death was inflicted upon Clifford Drake. And when we know from the facts of this case that the Wilkerson part of this didn't involve a discharge of the firearm, and there was this separate crime committed against him that didn't have to do with the death of Drake.
But I think because the jury was also instructed in giving the interlocking verdict form and told to consider 2, 4, and 5, or specifically 2 and 5 before they could reach 1, that we can't excise out this portion of this verdict, this portion of that verdict. We have to look at all of what the jury was asked to do as a whole. We also, I believe, it's important to remember that one of the things that is especially problematic in this case is the fact that we're trying to stand here today and argue and discern and try to figure out what the jury did and what the jury didn't do. One of the benchmarks of jurisprudence when it relates to jury verdicts is that they are supposed to be clear and concise, and there is not supposed to be room for ambiguity. That is completely lacking in this instance, and that's where you end up with similar to what you ended up with in LeBron, where you have what are seemingly inconsistent findings by the jury. The parties argued below, and everyone agreed, the state, the defense attorneys, and the court, that how do we take this forward? I mean, we can't square with what they did on counts 2, 4, and 5 with count 1. Now, I want to make the distinction, though, under the jurisprudence of this court, that is not what is considered a truly inconsistent verdict, where you simply cannot have the conviction of one count and then the conviction of the other count. So I am not arguing that these met that truly inconsistent standard, nor did this court find that in LeBron. What is seemingly inconsistent, though, is that the jury would make the finding of guilt as to count 1, but then either A, not make the specific findings related to who had possessed and who had discharged the firearm as to counts 2 and 5, and then as well as 4. The other thing that I think that it's important to note, to the degree that this ambiguity carried forward, is when we have to look at what the trial court felt it could do or not could do in the sentence in this case. Clearly, when the trial court reached the sentencing issue, you know, we have a sentencing paper in the record that we've had at least 2 different interpretations from both the state and myself. And reading it, it appears that the trial court either A, sentenced to a 10-year mandatory, which was not reflected anywhere else and isn't reflected on DOC's website when you look at what the offender sentence is. So if you take the second interpretation, which is it said that the trial court was not imposing minimum mandatories because there were insufficient findings of those facts regarding firearm possession and discharge by the jury. I think the trial court's determination that he could not sentence to those minimum mandatories based upon the jury's finding is also illustrative of what the trial court believed that the jury had actually done in this case. So then to go forward and allow in the penalty phase evidence that contravened what appeared to be the jury findings, which again, the jury was told 3 separate times, you determine guilt, but then you have to make these special findings regarding the firearm. Even in other cases where the jury is debating or finding guilt or innocence, we still require now those special findings regarding firearm possession and discharge. when the jury is told in that special finding, if this doesn't apply, leave it blank, are we to presume that the jury felt they found it already? Or are we to presume that the jury found that none apply? And I think, and my position is that it is not proper for us to say which one occurred. That would violate the whole principle of unambiguous verdicts. And if the decision has to be made which way the jury went, and we have to try to magically go back inside each of those jurors' minds and determine, oh, well, did you do this because you thought you'd already done it? Did you leave it blank because it really didn't apply? What were you thinking? That error should hew in favor of the defense, especially when you're talking about prior precedent from this court, which is very specific, that if we cannot say for certain what that jury found, then evidence that is contrary to that verdict.
But what am I missing? Why would we be speculating about whether the jury thought that they already found use of a firearm when, as Justice Kennedy and Justice Luck pointed out, they very clearly did find use of a firearm? We know that they found use of a firearm, so I guess they would think that, right? That's not speculation. They did find it.
And I would submit that based on the way that this very inartful verdict form was drawn, it is also possible and probable to speculate that the jury said, okay, he's guilty of this, but none apply as far as the firearm, and moved on. And so our position would be that when you have to begin to engage in that level of speculation about what a jury did or a jury didn't do, and there are two possible alternatives, that you do not then allow evidence under LeBron to come in that might contravene that jury determination. I think that then it becomes especially important then when you consider how that evidence was used in the closing arguments in this case. And I can honestly say that in 30 years of practicing in death penalty cases, I have probably never encountered a closing argument that was so fraught with problems, both promulgated by the prosecutor at the trial court level and the defense attorney in this case. You know, it is almost a laundry list or a primer on what not to do. The trial court saw fit at several points in time to even admonish the state during the arguments that what she was doing was improper and that she needed to steer clear of that. In one fairly glaring instance, the state made an argument at the very opening of her closing argument, which was objected to, and the trial court sustained the objection, and she repeated almost verbatim, in fact said, I'm going to refer back to my prior argument at the end of her summation, and repeated an argument that an objection had already been sustained for as being improper. I believe that if you go through many of those instances, it is not possible to find or to determine that they are harmless error under this court's prior precedents. In particular, I would like to highlight the issues with arguing to this jury that the death sentence would be a deterrent. This court has never permitted that type of an argument to be made. I also believe that the focus on the numerical valuation of the aggravating circumstances in this case also is particularly problematic, both as it was used in the submission to the penalty phase jury, the closing arguments of the parties, and then how the judge evaluated the aggravators in the sentencing order. I was unable to find a single case dating from this court's reapplication of the death penalty and Spinkelink forward that has ever permitted, condoned, or authorized the prior violent felony aggravator to be found independently and separately for each prior conviction. The effect of that in this case was to tell this jury that this was an 8 aggravator case. when under the law, this was not an 8 aggravator case. It was a 2 aggravator case. The trial court made the same error then in his sentencing order, finding this to be a 5 aggravator case or a 4 aggravator case, depending on whether you, on how you interpret the contradictory handling of the pecuniary gain aggravator. The judge certainly at one point, verbally stated that he was giving that substantial weight, but then in the sentencing order appeared to merge it. So I think there's some ambiguity there of whether the trial court actually found it to be a 4 aggravator or a 5 aggravator case. But under the case law from this court, and again, I was unable to locate a single case that would authorize the method that was used in this case to present.
And this was the way it was agreed to by the parties, correct?
Yes and no. Certainly on the verdict form, the original verdict form that the parties agreed on and everyone thought they were going to move forward on was altered by the trial court. He did not make substantial, the actual or original verdict forms that the parties proposed were not in the record, just the final verdict form that was used. But I don't believe there was substantial alteration to the aggravation. But yes, the parties did all do this. In fact, as was argued in the initial.
And the way it was done did not mean that the jury heard any additional evidence that they would not have done if it had been presented as a single aggravator. In other words, the state still would have been able to establish all the other felonies.
I don't believe that the jury heard additional evidence subject to my prior arguments about what should have been excluded as evidence. However, I do think that when you have a state attorney who, during her penalty phase voir dire, informs the jury that out of 60 pending first-degree murder cases in their office, only 9 might warrant the death penalty, and this is one of them, then the prosecutor goes on to highlight that this is certainly a case with 8 aggravators and spells each of them out over and over. The defense attorney repeats that incorrect and improper argument under the law of this court, and then the court instructs the jury under what is not the law from this court regarding how that felony aggravator is to be presented. Then yes, I do think that that is reversible error, even if additional evidence might not have come in.
So since there was no objection with respect to this particular issue, it's a fundamental error standard, and I'm just struggling sort of conceptually to see how it weighs out differently when we're talking about a weighing process. So if I present 8 1-pound weights and say, weigh them against the mitigation, or 1 8-pound weight and say weigh it against the mitigation, it seems like the weighing is going to be the same conceptually, and so I'm struggling to see how that's harmful, and certainly how you could possibly meet a fundamental error standard.
I think that where it becomes particularly harmful is the state emphasized each one individually. And I think that for most of us, as humans, we tend to look at something and say, more must mean worse. More equals worse. And so when you have a jury that's, again, already been told, we've already decided as the prosecuting authority that this is a special case that merits the death penalty, and it's one of 9 maybe out of 60, and then the jury is told over and over, well, there's 1, 2, 3, 4, 5, 6, 7, 8, as opposed to, you can consider the fact that the defendant has prior convictions, and you're allowed to assign weight to them.
Again, back to the point earlier, there's no suggestion that the state was not entitled to put on evidence of all those prior offenses, is there?
No, the state was allowed in the penalty phase to present evidence.
I'm just struggling to understand why it's not appropriate for the jury to consider that history of violence that has been perpetrated by the defendant here, in assessing the aggravation and weighing everything. That's the reality. That's the reality that he created. Why would they have to be somehow shielded from confronting that? I'm struggling with that.
I don't believe that under this court's prior jurisprudence that instructing the jury that they can consider the fact that the defendant has a prior record and that they can consider and weigh that prior record diminished that. I don't believe that there is a legitimate reason for this court to abandon what has always been and the way that the statute requires this to be presented in favor now of a process which would allow a separate, independent, and distinct aggravating circumstance for each of a defendant's prior convictions. If you look at death penalty cases as a whole, the number of cases for which there are 8 aggravators are few and far between. There are not even 8 statutory aggravators total. So by permitting this to happen, you are in essence allowing the state to grossly inflate in front of a jury. And again, I disagree respectfully. Numbers are important. Numbers are important. And if I only have 2 aggravators versus 8, I do believe that in the eyes of a penalty phase jury, who, as we heard in the prior argument, may not be versed in the law.
Are you suggesting that with mitigation, we should come up with categories and force the defense to present them as limited? This is all of his history. I mean,
no, in fact,
because the defense does exactly what you're saying. The state, has prejudiced your client.
The difference, I believe, there is that statutory aggravators are limited, and they are only those that are permitted to be used. Whereas in mitigation, not only do you have the statutory mitigators, but in order to preserve the constitutionality of the death penalty sentencing scheme, we have to have the catch-all mitigator.
It just seems odd that given that our law assigns greater weight to certain of those factors, that if we accept the argument that numbers matter. I mean, we've said that there are certain aggravators that are entitled to much greater weight, and that they alone could outweigh significant mitigation.
Correct.
Compared to others. In other words, we've said numbers don't matter. Quality matters, not quantity.
But in this case, we made numbers the entire focus. We made numbers the focus in this case is 1 out of 9 cases that qualify for the death penalty. We've then made this case appear to be more aggravated under the law, as we have been using for the last 30 years than it was, by claiming that it is an 8 aggravator case as opposed to a 2 aggravator case.
But the number doesn't affect the weight. In other words, I think...
We don't know that. We don't know that the jury couldn't have looked at this and said, wow, 8, this is 8. I mean, and the state's already told us, this is a case that they think qualifies for the death penalty. I think a natural assumption would be the others must be less. This court has also, although it has said, aggravators, the number are not determinate in the appellate review of a death sentence. We are dealing, and as was talked about in the previous argument, we have jurors who don't know the law. They don't understand or necessarily
Counsel, you have now consumed about half of your rebuttal time.
Right.
If you want to keep going, you
No,
can.
I'll finish and save the remaining 2 minutes. Thank you.
May it please the court, my name is Lisa Martin. I represent the state of Florida in this matter. The first thing I want to address is the pecuniary gain aggravator. And while reviewing the record in preparation for this argument, I reread the sentencing hearing, and the trial court did not give any weight to the pecuniary gain aggravator. However, in his written sentencing order, he gave it substantial weight. So at this point, we would like to ask for you to strike the portion of his written sentencing order that assigns weight to that aggravator. So just going through some of the issues that opposing counsel discussed, issue number 6 had to do with the verdict form. Any alleged ambiguity in this verdict form was not raised to the court before the jury was discharged. These types of problems are required to be raised, otherwise they're waived. So there was no way to discuss with the jury to find out if there was anything wrong, if the jury question indicated that they were confused, if that led to them not filling out these special verdict questions. So we would argue that that is a waived issue. As far as the closing arguments, the standard is that the collective prejudice of the objected to and the unobjected to statements must be so prejudicial to vitiate the proceeding. It's not a harmless error standard. The comment about the death sentence being a deterrent, opposing counsel said that it's never been upheld to be proper. It has been found to not be fundamental error, which is what this court would review these statements for, and that was in Gibson. It was also found to be proper in Kennedy, where it was where the prosecutor is making a comment that the defendant's prior murder didn't deter him from murdering again, and that was proper as it spoke to aggravation. Concerning the comment that there were perhaps 60 homicide cases in the circuit, and only 9 may have been eligible for the death penalty, that taken in context is not improper. The prosecutor was speaking with jurors who said that they were ardent supporters of the death penalty, and the prosecutor was explaining to them, well, listen, not every murder is death eligible. There are requirements, there are legal requirements. And this court in Brady said that that's an appropriate comment on the legal framework of how the imposition of the death penalty is imposed. Concerning any the listing of aggravators, I know this court already pointed this out, but there is no fundamental error in listing the aggravators separately. Although unconventional, all of these same factors go to the jury. They have to make a decision on each and every factor, and they have to do a qualitative analysis, and they're instructed that the analysis is not quantitative, it's qualitative, and jurors are presumed to follow instructions.
I guess a couple questions regarding that. First of all, in a post-Hurst world, doesn't it make sense to set them out individually so that we know what the jury, whether it's unanimous or not, and what the jury breakdown is?
I would agree with that.
In fact, that counsels in favor of it, wouldn't it?
Yes, I would believe that it's more helpful to have them delineated in that manner.
And then in the weighing process, in other words, even when they're combined, as the trial court did in its sentencing order, wouldn't it be relevant to the trial court whether the jury did not find some of those individually as opposed to finding some individually? In other words, if the jury didn't find pecuniary gain but did find the commission of the prior felony or commission during the course of but not for pecuniary gain where they're later combined, wouldn't that be relevant to the weighing for the trial court?
Yes, I believe it would, which also goes to the second part of that issue concerning the mitigation, and I believe that it is helpful.
I just want to back up.
Okay.
As a matter of strategy, wouldn't the defense want that so that the defense could argue that some of these are not there, such that it could argue weight both at the Spencer hearing and before the jury, and that some of these aren't in fact there, and therefore the mitigation should outweigh the aggravation?
Sure, I believe in a case where certain aggravators weren't found, the defense may not be making this argument.
And indeed, the defense didn't object to this. They also wanted the individual aggravators to be separated out, correct?
Yes, they agreed with this.
Right. In other words, there seems to be some good reasons why they would want that very thing.
Sure. Sure. And in this case especially, there's no way that it affected the jury recommendation because the jury was presented with several different mitigators. They were presented with 4 statutory mitigators and 3 under the catch-all. And the jury only found 2 of those 7 mitigators. And they found, and actually in one of them, the first, that there was no significant prior criminal history, they asked a question on that because the prior murder of Carmen Riley, that happened 3 weeks before this murder. So the jury question was whether they are supposed to disregard that murder in assessing this first mitigating circumstance.
Can I, sorry to interrupt you, I just want to make sure I understand your argument, because I think part of this is attributable to the timing with Hurst and everything, but it sounds like no one has been able to find examples of this having been done exactly like this. And so I'm curious what your position is for us going forward. Is it your position that there's nothing about the way this form was put together and the instructions that it was in any way error, putting aside the question of harmless error or fundamental error? I mean, is it your position that we should write something saying, here's the way it was done here and this is perfectly appropriate for future cases?
I do think it's appropriate. I don't think that it's error. I think that the weighing process is qualitative and all of these factors are to be considered, whether you list them 1 to 8 or 1 subsection A, B, C, D, E, 2 subsection A, B, 3, in this case there was no subsection. But I don't think it matters either way. I think it's perfectly permissible to do it this way. So going forward, I think either option would be fine.
So even if the verdict form is okay to do it that way, is it okay for the state then to at least imply that aggravation outweighs mitigation because of the number?
No, not because of the number.
But would it be okay for the state to make that argument? Even though you knew that the state would know that some of them are going to be combined when it comes time for the trial court to issue its sentencing order?
Well, no, and also this jury was instructed as to doubling on 4 of these 8 factors. So they were instructed that certain, in their weighing, certain aggravators are going to be merged. So, and also the trial court does it as well.
So as long as the trial court does it, the jury's instructed of it, then the jury properly understands its role in weighing the aggravation and mitigation.
Yes.
And so it's okay in the case where there's 6 prior contemporaneous felonies, it's okay to refer to that as 6 aggravators?
Aggravating factors.
Aggravating factors?
Yes, I believe so.
Okay.
If there are no further questions, the state would ask you to affirm the judgment and sentence.
In rebuttal, I would argue that no, that is not proper, Justice Munoz, for that to be done. If the court is going to maintain that this is a qualitative and not quantitative analysis, then there would be no basis to allow a process which would enhance the quantitative.
What about the fact the jury was instructed, though, exactly the role of each of these aggravating factors?
The jury may have been instructed, but even in this case, the trial court didn't get it. I mean, we don't know that the jury did that or didn't do that. 3 weeks before.
We have to presume, though, the jury follows its instructions, don't we?
As we had to presume they followed them in the guilt phase. In this instance, though, one of the things that I think that it's important to note when this was being done was this court had promulgated the standard jury instructions 3 weeks before the trial. Presumably, this court did that in light of Hurst. In fact, they were done, I believe, in light of Hurst, the new adoption of the jury instructions in verdict form. And this court, 3 weeks before the trial, did not see fit to decide that under Hurst now, the jury must make a specific finding of aggravation as to each individual prior conviction. This case, there were...
As a strategic sense, doesn't it make sense, though, for defense counsel to ask for that?
Personally, as a
in the same
defense
way that
attorney,
they would ask for each of the mitigators to be laid out?
This court also, in a year later, in the standard jury instructions, specifically did not require the jury to identify each mitigating circumstance they find, nor to provide a numerical vote whatsoever on mitigation. So sometime between April of 2017 and the following year, we decided that, the court, in adopting that verdict form, decided that jurors are not going to be required to identify each particular mitigating factor. That is something that we rely on the trial judges to do in their sentencing orders under Caldwell, but we have never required the jury to make that. Even prior to Hurst, this court rejected, especially in particular from Justice Periente's request, that juries be required to make some type of specific findings regarding mitigation. So to have the jury do this on the verdict forms, especially when this court has never asked for that before, and again, if we are going to focus on the quantitative and not the qualitative as opposed to the quantitative, what do you do with an individual who has 25 prior convictions and half of them are for petty theft? Are we going to now require juries to have verdict forms and penalty phases that require the finding of each and every prior conviction, no matter how many, and then try to say that numbers don't count? If numbers don't count, then there is no reason to deviate from what has been the accepted practice in the law in this court for 30 years. Thank you.
All right, well, we thank you both for your arguments. The court will now be recessed.
All rise.